Like just that, not
What's the
jump.
question?
Okay, sorry.
But
Can I like sit like this and still be fine in the photo or in the video?
Just
I
don't like
just don't wanna,
swivel
like-
back and forth too much, I guess. Yeah, that's it.
Jonathan, you're the one doing hand signals, right?
Alright.
Oyez, 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 the Supreme Court of the United States is now in session. The Honorable Chief Justice Gill presiding. All those having cause to be before this honorable court, draw nigh and pay heed. God save the United States and God save this honorable court.
May be seated. The court will hear argument this afternoon in case number 071626, Valdez v. Wilcox. Is the petitioner ready?
The petitioner is ready, Your Honor.
Is the respondent ready?
The respondent is ready, Your Honor.
You may proceed.
Madam Chief Justice, and may it please the court. My name is Grant Shore, and I'm joined by my co-counsel, Miss Bridget Davis. We represent Sabrina Valdez in the case at bar as the petitioner. I will cover SCOTUS precedent, and she will cover common law precedent. We would like to reserve 2 minutes for rebuttal.
Granted.
Thank you. On July 15, 2014, Serena Valdez was shot in the back by officers Wilcox and De La Vega as she was driving away from them. The question thus being presented before this court is whether or not this constitutes as a seizure under the Fourth Amendment. We would argue that the act of putting bullets into the back of De La Vega would constitute as a seizure. If it isn't, we will be leaving a citizen without any help or protections on her road to recovery. Because of this, I urge you to overturn the previous court's ruling. The first point I would like to present is that there is no true precedent for this case. There are cases that are in the ballpark, but none of them are truly similar enough that we can draw from them one-to-one. The first instance of this is the case of U.S. v. Mendenhall. The lower court used Mendenhall to argue that freedom of movement needed to be restrained in order to constitute seizure. This case, however, is by all purposes irrelevant to this case, as in Mendenhall, she was never touched.
Excuse me, Counselor. Can you tell us how you deal with Mendenhall? You mentioned that here, and Mendenhall clearly says that seizure requires, and I'm quoting, his freedom of movement is restrained. How can you say Valdez's freedom of movement was restrained in the facts of this case?
Well, if we want, well, Your Honor, but first of all, we can address the freedom of movement thing in arguing that, well, her arm, it was temporarily paralyzed when she was shot, which I think could constitute as freedom of movement being restrained. If you cannot move your arm, it's one of your movements and it's restrained.
Is it not true she didn't know that immediately upon being shot? She continued to drive some 70 miles to another city. How can you maintain that her arm was paralyzed, constituting loss of freedom?
I mean, I think, Your Honor, it stands to reason if you might be able to move other limbs, but if one of your limbs is restrained, your liberty to true freedom of movement is restrained if one of your limbs is restrained. In the case of, another case that might be brought up is Brower versus County of Inyo. In this case, the officers of County of Inyo were chasing after William James Caldwell in a high-speed police chase when they placed an 18-wheeler semi-truck across the road, and he slammed into it and died from his injuries. When it was presented to this court, the question was whether or not seizure can be done with intent. And of course, it was decided that it did constitute as seizure. The reasoning they gave in Brower, however, is applicable to Brower himself and not necessarily all future cases. I think I would say it stands to reason that if one slams into a semi-truck and is dead, he is seized by all intents and purposes. A third case that can be brought up is the argument of Brenlin versus California. In California versus Brenlin, Bruce Brenlin was riding in the car of a friend, and when the car was pulled over for a routine traffic stop, Brenlin, being recognized as a parole violator, was seized at this point. The question before the court in that case was whether or not a person is seized when the vehicle stops. The court decided that yes, a person is seized when the vehicle stops, but there can be many more things to constitute a seizure than merely stoppage of a vehicle.
Excuse me, Counselor, go ahead. Chief Justice.
Counselor, doesn't Brennan also say that seizure requires an actual submission? And if so, then don't they also say he's not seized until, quote, he is physically overpowered? So how would you respond to that?
I would point to the case of Terry v. Ohio, Your Honor. In Terry v. Ohio, we see it stated that a person is seized upon initiation of contact. So I would stand and argue that the initiation of when the bullet made contact with Mrs. Valdez, seizure was conducted at that point. Another piece of dicta from the case of Terry v. Ohio is that, one second, Your Honor, my apologies.
Yes, Counselor, question while you're finding your place there. How are you defining dicta?
Dicta is whatever. Are you asking for the direct definition, Your Honor, or?
Your understanding of what dicta is, since you just referenced it. This was another part of dicta in this particular case.
Yes. To my understanding, dicta would be that which is part of, that which agrees with the ruling, but is not necessarily what caused the ruling to be done.
Determined to the outcome. Okay. Thank you, Counselor. Proceed.
You're welcome. Another piece of dicta from Terry is, and I quote, "Only when the officer, by means of physical force or show of authority, has in some way restrained the liberty of a citizen, may we conclude that a seizure has occurred." We can see that because the bullets hit Mrs. Valdez in the back, that her liberty to personal security and safety was restrained.
So, Counselor, you keep referring to Hodera D as dicta, and we've defined it. You yourself have defined it. So, why should we be using this case to discuss this Valdez case, who was actually touched? In the case that you're referring to, there was no actual touching of the individual.
Well, Your Honor, in Hodari D, it is in essence a common law case. So then you would look at the concept of common law and whether or not mere touch doctrine applies, which is what was discussed in Hodari.
Thank you.
With that being said, as it is a common law case, more of that discussion I will leave for my co-counsel. But it is dependent upon the Fourth Amendment, I do have some things I can say regarding it. As the Fourth Amendment was written based on the common law precedent at its time of writing, it's thus reasons that we should look at that common law and what was being decided and what the concept of seizure was at the time of the writing of the Fourth Amendment. That means that, yeah. That's all my stuff.
Petitioner one has eclipsed his time. Excuse me. Okay. We're confused here on whether he has more time.
I have
Oh,
more time. I have more time.
Okay,
Your Honor.
so
I
let's.
just ran out of
We
space.
have some questions for you, I'm sure.
Yes.
So you're referring to common law, but let's talk a little bit about common sense here, Counselor. Doesn't common sense basically say if someone escapes, they haven't been seized?
Well, that may be what. Well, Your Honor. Well, that may be what common sense would dictate. As a court, we cannot operate on common sense necessarily. We can take into consideration, but if we were to operate every case by just common sense, every case would have to be interpreted entirely in and of itself, and we cannot look at other writings, be it from cases or the Constitution or whatever it might be, to constitute that. We need precedents to dictate what is and isn't legal and what to make rulings by.
So let's make sure we understand what we're talking about here. if, let's say, that the police had touched the petitioner here with just the tiniest portion of their finger, you're saying that that would constitute seizure?
By the definition of the law, you are correct, Your Honor.
Definition of the law or common law or of the actual understanding of the Fourth Amendment?
Could I have that rephrased, Your Honor?
Are you talking about, when you said according to the law, are you talking about the actual wording of the Fourth Amendment, or are you talking about common law interpretation of the Fourth Amendment?
Common law interpretation, Your Honor.
Thank you.
Counselor, you were a moment ago talking about what the understanding, or I guess I would interpret as the public meaning, at the time that the Fourth Amendment was drafted, that we were supposed to use that as a baseline to understand what was intended. I'm curious how the understanding and the language at the time of drafting, how that influences how we interpret it today.
Ms. Chief Justice, may I have time to answer your question?
You may.
Thank you. Could you rephrase it real quick for a second?
Sure.
Apologies.
Sure. So we are discussing an interpretation of the Fourth Amendment today, and I was asking your understanding of what was meant at the time the Fourth Amendment was drafted. How does that influence, if it does, how we should go about interpreting what the Fourth Amendment means today?
Well, Your Honor, we need to look to the past, because if we look to the definition of seizure as it was written in the Constitution and the understanding of that word at that time, we then have one definition that we can apply to all cases throughout all of time. If we were to interpret seizure as it might mean in 1950 or 1976 or 2003, if you interpret it seizure based on the definition of the current time, the definition will change over time. That's why we need to look at the definition of seizure as it was understood at the time of the writing of the Fourth Amendment.
So is it fixed forever at the time of the drafting, even though it might change over the centuries then in public usage?
Correct, Your Honor.
Thank you.
Thank you.
Your Honor, may I proceed?
You may.
Madam Chief Justice, may it please the court. My name is Bridget Davis, and I'm here to represent Serena Valdez in the case at bar with the issue of common law. The Fourth Amendment says that there shall be no unreasonable seizures. To answer the question of what a seizure is, we must not only guess in today's terms. We should look at the history of what the word in the era when the Fourth Amendment was drafted. This is the purpose of common law. I argue that common law is abundantly clear that any amount of physical force, no matter how large or small, constitutes as a legal seizure. For that reason, I ask the court to overturn the decision of the lower court. To that end, I submit 2 lines of argument. That common law is applicable to the Fourth Amendment, and that common law states that applied physical touch, no matter how vast or small, is reasonable enough to be a seizure. My first argument is that common law is what the American public knew when the Fourth Amendment was ratified. Common law was the basis of what the early American people understood when they read the founders' protection of the people from unwanted seizures in the Fourth Amendment. The concern of the Fourth Amendment is to protect against an interference of a person's security. The court has recognized that the Fourth Amendment, since its founding, protected a person from unreasonable seizure with understanding from the meaning of common law.
Excuse me,
Mere
Counselor, but why should we be caring about common law if we do not have Supreme Court precedent?
Your Honor, we should care about common law because common law is applicable to civil and criminal cases. In the case of California,
How so? How is it applicable to, without a Supreme Court precedent, why does its applicability to civil and criminal, why does that matter?
Your Honor, I would argue it matters because common law can help in the understanding of what a seizure is. And criminal cases cases deal with seizure, and so do civil cases.
So let's back it up one step. Would you define for us, please, how you are using the term common law?
Your Honor, we are using the term common law to understand if there is a kind of physical touch, if there is an intent to detain or submission to authority. The explanation of seizure is clear when you use common law in the Fourth Amendment. An explanation from Hadari D. is we have long understood that the Fourth Amendment protection against unreasonable seizures includes seizures of the person, and that an arrest is the quintessential seizure of the person under the Fourth Amendment jurisprudence. We can also understand that our founding fathers' intent of the word seizure by looking at the available definitions of the word at the time. Some available definitions include the term from the New and Complete Law Dictionary, explaining from 1771, explaining that any citizen may lay hold of a person in order to arrest him, and that if the bailiff had merely touched a man, that would have been an arrest. The definition from the Dictionary of the English Language is to take hold of by force. I understand that there could possibly be an argument made by the respondents that the term seizure does not mean just a mere touch, but supposedly, according to the latter, it would be interpreted as a possession. The rebuttal, Your
So
Honor.
as you're talking here and about the Fourth Amendment and in the original language of the Fourth Amendment, did that not deal mostly with debt collection rather than criminal cases and criminal offenses?
Yes, Your Honor. Those common law cases did deal with debt collection, but our founding fathers used those cases to help interpret what a seizure is. And we can see that those common law cases that deal with debt are applicable to criminal cases, as we see in Hadari D. A rebuttal to that argument is that while we may think of the term according to definition as not applicable to the way we are using the word, it actually still helps us because the definitions still agree to some kind of touch to the person with an applied force.
So, Counselor, so far it sounds like we're discussing physical touch as the individual is physically touching, using a part of their body to touch another. What happens if you have an intermediary device like firing a weapon? How does that still constitute touch?
Yes, Your Honor. We have a common law case that deals with that, and it is called the Countess of Rutland, in which the Countess is arrested but because the bailiff is extending a mace and says that she is arrested. And they have applied that it is an arrest, and even though the case is not explaining if she was arrested or not, it's explaining if she, as a countess, could be arrested or not.
Was that not the essence of that case? Was the case turned on whether or not the Countess could actually be arrested?
Yes, Your Honor, that was the case, but it does apply that she was arrested by the bailiff. This leads to my second argument, that in Hadari D.
Question, Counselor. Is there a difference between arrest and seizure in this case?
Your Honor, I don't believe there is really much of a difference between a seizure and arrest. I believe an arrest is a subset of a seizure. Before and after the founding period in our history, judges and commentators agreed that as a fact, that mere touching with the intent to arrest was indeed a seizure, even if the one in question was not brought under full control. Hadari D.
Counselor, are you
mentions-
familiar with the case Josefa Segunda?
Yes, Your Honor.
Okay, so didn't the court in that particular case say there needed to be clear proof of possession of something in order for it to be considered a seizure? How in this case with this petitioner was there any kind of possession by law enforcement?
Your Honor, in the case of Josefa Segunda, it is dealing with a particular item, which was the ship, and not a person's body, as in the case of Valdez.
So you're making a distinction between possessions and person?
Yes, Your Honor.
So you're saying that possessions are not seized if I merely touch them, but people are?
Yes, Your Honor.
Thank you.
So, Counselor, follow up to that then. Was using that line of reasoning, was Valdez's car also seized by police and the vehicle was struck by gunfire as well as Valdez?
No, Your Honor, because there was no physical touch to the person if it had just hit her car. Sorry, Your Honor. Under common law, there is no argument as to whether a mere touch with the intent to restrain is valid, and therefore it is an arrest, which makes it a kind of seizure. Even if the one in question fled from capture, when what could be more physically intrusive to a person's body than to pierce the body with bullets, and with the purpose to hopefully stop them and to detain them. In conclusion to this argument, it is evident that the founding fathers used their understanding of common law to influence their writing, and on the writing of the Fourth Amendment, and that common law is about mere touch to a person's physical security that defines a seizure. We therefore ask the court to overturn the lower court's decision. Thank you.
May I proceed, Your Honor?
You may.
Hello, Madam Chief Justice, and may it please the court. My name is Zipporah Schaefer, and I am joined by my co-counsel, Ms. Catherine Yorkie. I represent Riley Wilcox, respondent in the case at bar. I'll cover this court's precedent, and my co-counsel will cover the common law precedent. As you have already heard from the petitioner, the issue before us today is what defines a seizure. I would like to take a look at the meaning of the word seizure in the context of the Fourth Amendment, and that seizure under the Fourth Amendment does indeed require restraint of movement. Secondly, we will look at the findings of the court that prove restraint is required for seizure to occur. The Fourth Amendment states, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated." The definition of seizure, according to a Dictionary of English Language, Volume 2, which was written only 23 years before the Fourth Amendment, is to take possession of by force, to make possessed, or to put in possession of. This court has upheld the standard of not using the same word to describe two different things. So how can you only
Counselor,
seize...
question for you. We just heard a lot about common law
Yes, ma'am.
from the petitioners. Are you saying that the dictionary definition then basically constitutes common law?
No, Your Honor, I'm not saying that common law in itself is not applicable. I do believe that the cases that they've brought up are not applicable because these are all civil issues and about debt collection, and also the use of mere touch in common law is what defines whether the person collecting the debt was allowed to break and enter into the home legally, not whether the person was actually seized. So I would like to ask, how can you only seize a house, paper, or effect by taking control of it, but a person is just somehow different? Can you just use a different meaning for a word because it benefits you more? No. The Noah Webster American Dictionary definition is to take possession of by force, with or without right. As you can clearly see, if I have seized an object, I must have full possession of it. So why would a person be any different? If a seizure of an inanimate object requires the complete control of said object, shouldn't a person be judged seized or not seized by the same standard?
Counselor, do you not believe being paralyzed constitutes loss of freedom?
Yes, Your Honor, I believe being fully paralyzed and in control of the officer would. The way that they use the freedom and the liberty to move in this case, or in cases similar to this, is not whether I can move my arm, but whether I am actually physically able to leave and flee the scene, which in this case Valdez absolutely was. The writers of the Fourth Amendment saw fit to include people along with houses, papers, and effects. So they should therefore be considered seized by the same standard. You would not consider, a car seized just because it has been shot. You would have to have had physical control of the object for it to have been seized.
So she would have been considered, if she had been fully paralyzed, like shot from the waist, if she was paralyzed from the waist down, let's say, would that constitute loss of freedom in this situation if the gunshot hadn't been in her arm or shoulder, but
No, Your Honor. Her actually being paralyzed does not constitute a seizure. If, let's say, she'd been paralyzed and, for example, her cruise control was set and she was still able to drive away, she still has the freedom and the ability to leave the scene and is therefore not in control of the officer and not seized. I would also like to bring up the case of Hadari D that petitioner has mentioned. The case of Hadari does not deal with physical contact, but about whether a person was seized while the officer was chasing after him. In contrast, the cases of Terry, Brower, and Garner deal with actual physical contact, and the court gave definitions of what is needed for a seizure to actually occur. The cases of Mendenhall and Brennan may be considered dicta, but they are also examples of this court holding to the same standard as they did for Terry, Brower, and Garner.
Counsel,
Whereas-
I'll ask you the same question I asked your colleague. What are you defining as dicta?
What I have been, Your Honor, explained to you as the definition of dicta is dicta would be anything that is not actually the court's ruling in the decision. So any other words that are used that way or arguments that are made that don't have to do with the direct case in itself.
Okay, so how are you differentiating, saying that Hodari D is dicta while Mendenhall, Brennan, Brower, and Terry are not?
Yes, so Terry, Brower, and Garner have to do with physical contact, and any
It's the
quotes,
physical contact.
yes, that have to do with them are applicable to the actual case in itself, whereas Hadari has absolutely no physical contact until Hadari was tackled and he was considered seized at that moment, also by my definition.
Okay, thank you, counsel.
Hodari is a standalone example of this court mentioning mere touch as a hypothetical of the actual case. Even if there is no physical contact between the person and the officer, the person must at least submit to a show of authority and therefore be under the control of the officer to be considered seized.
okay, so let's talk about that for a moment. Let's say that the bullet stopped petitioner for 5 or 10 seconds, that there was an obvious halt in her moving of the car. Would that then constitute seizure?
It would depend, Your Honor, on whether the police officers were able to actually take possession of petitioner or whether they were so far away that she simply continued to drive off afterwards.
So, counselors, physical control then only, is it a proximity issue? You're only under physical control if the officer has his or her hands on you? You can't seize a vehicle from a distance, you can't seize an individual from a distance?
Your Honor, I would define physical control as a reasonable witness or bystander watching would be able to have a definite moment in which they could say that person was under the control of the officer. Even if there is no physical contact between the person and the officer, the person must at least submit to a show of authority and therefore be under the control of the officer to be considered seized. This court has previously stated that a police officer may make a seizure by a show of authority and without the use of physical force, but there is no seizure without actual submission. Otherwise, there is at most an attempted seizure so far as the Fourth Amendment is
So
concerned.
if they had been able to pull the car over and that would constitute a seizure, how would someone being shot at by law enforcement not constitute a seizure?
I believe you're referring to the case of Brennan, Your Honor? Yes, so in the case of Brennan, the people driving the car and in the car submitted to the show of authority and were under the control of the officer when they were pulled over. If they had driven off, it would not be considered seized. In this case, the bullets were shot into the car never actually stopped, and I do not believe that mere touch constitutes a seizure. Brennan, as just mentioned, deals with the car being pulled over and whether the seizure of the passenger occurred when the car was pulled over or at the formal arrest of the passenger. It was ruled that the passenger was seized when the car was pulled over. In this case, physical force was not necessary because they submitted to the show of authority. As
Are
this
you
court,
concerned, counselor, that according to your definition here, that people in situations like this petitioner basically have no legal recourse in these kinds of situations under your definitions? And
Your Honor, the issue
Openness.
before us today is not whether the petitioner is able to have a tort law that will actually be passed or not, but the issue before us today is how will this word be defined in future cases after this. As this court has previously stated in the case of Brenlin, a fleeing man is not seized until he is physically overpowered, but one sitting in a chair may submit to authority by not getting up and running away. This case, I already said that. This brings us to the fact that petitioner was not seized. Even though there was physical contact, there was no seizure because she was never under complete or even partial control of either officer. According to Mendenhall, page 554, a person has been seized within the meaning of the Fourth Amendment only if, in view of all the circumstances surrounding the incident, a reasonable person would have believed he was felt not free to leave.
you
And by
didn't seem very
petitioners-
fond of dicta from the previous case, from the Hadari D case. Are you citing dicta from Mendenhall?
I am citing a dicta from Mendenhall because it corresponds with actual ruling from cases such as Terry and Brower that do have dealt with physical force, whereas Hadari is a standalone area. Your Honor, may I have a moment to conclude? I see that for another time. Thank you. Additionally, in Brower versus County of Inyo, this court reasoned that whenever an officer restrains the freedom of a person to walk away, he has seized that person. Not only was petitioner able to walk away, she was able to get out of her own vehicle, hijack a different car, and drive 73 miles to a hospital. This is obviously not a case of seizure according to the Fourth Amendment. Therefore, we ask this court to affirm the decision of the lower court. Thank you, Your Honor.
May I proceed? Madam Chief Justice, and may it please the court. My name is Catherine Yorgi. I represent Riley and Wilcox in the case at bar. I will cover the common law precedent for this case. We will present the following two arguments. One, that common law does not apply simply because they were on debt collection. And two, mere touch does not constitute a seizure. First, I'd like to propose the common law cases brought up by the petitioner do not apply here because all cases of mere touch have been debt collection cases. But the only reason mere touch was counted as an arrest in that time was because they needed the authority to be able to enter the home, such as Isabel Countess of Rutland, Sandon v. Jervis, Whitehead v. Keys, and Jenner v. Sparks. Unlike this case in which this was a criminal arrest, not a civil, and older laws do not apply to violent modern police arrests. I'd like to highlight one case in particular, the case of Sandon v. Jervis. In this case, the officer was sent to arrest Sandon. The officer saw an open window around the back and grabbed a ladder and climbed up that ladder to reach into the window to touch Sandon. At that time, there was an occupant in the home who shut the window in such a frenzy and with such force. The window broke, which allowed the officer to touch Sandon. And then he was able to forcefully enter the home and arrest Sandon. But this is not at all.
Does not Sandon versus Jervis indicate that mere touch does constitute seizure?
No, Your Honor, as my colleague had previously stated, that it was just there to allow them to make the arrest.
So in other words, the arrest or seizure did not happen until there was complete possession, if you will, of the individual?
Yes, Your Honor. In this area, we don't see people running around the backside of houses, climbing up ladders, and reaching through broken windows just so that they can arrest someone else. Debt collection is done in a calm way through communication where we offer payment plans. So as you can see, common law and mere touch would not apply in any way to this case. Arrest only happens when the officer has possession of the person being arrested, according to Samuel Johnson's Dictionary of the English Language, Volume 2. Which takes me to my second point. Mere touch does not constitute a seizure. And if the court were to rescind the ruling, you'd be making mere touch the precedent for all cases that are remotely similar to this one, so then where would the line be drawn? If I were to touch your chair, Your Honor, would it then become mine? By no means. If I were to touch your house, would it become mine? Of course not. That is a completely irrational and ludicrous statement. So then, if when she got shot, it was counted as a seizure, it was said that her car was hit the other 11 times. Would then her car be under their possession? Where would the line be drawn? Throughout all the
So
deaths.
let's back this up for just a moment. And this court deals with constitutional issues. We're here today basically talking about the Fourth Amendment. And let's discuss then what you think the Constitution requires, or does the Constitution require a seizure to be full control? The Constitution itself, the Fourth Amendment, the applicability of that particular amendment.
Yes, Your Honor, I do believe that at that time when the Constitution was written, the Fourth Amendment counted it as possession. There, in Samuel Johnson's dictionary, it says the definition of seizure, which Samuel Johnson's dictionary was written 23 years before.
In England.
Yes, before the Constitution was written. So at that time.
So now we're allowing international definitions to apply to American law? Samuel Johnson wrote one of the first dictionaries ever of the English language. Astute man that he was, excellent with words. Does it apply to us in America, even in that period of time?
Yes, Your Honor, I do agree that it would, because at that time that was a clear meaning of the word seizure across multiple countries. As I was saying, Samuel Johnson's dictionary says that the definition of seizure is to take hold of, to grasp, to take possession of by force, to lay hold on. Noah Webster's dictionary says the definition is to lay hold of, to grasp, or to fasten, as well as the dictionary of terms and phrases used in American or English jurisprudence. Of all these.
Counselor, we've heard both you and your colleagues across the aisle use and refer to multiple dictionary definitions to help us understand what a seizure is. How do you know which definition is the correct if you have dictionaries that are both agree, but also where dictionaries disagree on the definition of a term like a seizure? How should the court know which dictionary definition to go with?
Your Honor, I believe that this specific dictionary should be used because of the fact that it was written the closest time to when the Constitution was written in the Fourth Amendment. Another point is that the definition, that if the definition is to take under control or to lay hold of, she was not arrested until she had been airlifted back to Albuquerque. The petitioner may try to tell you that the meaning of seizure comes from common law arrests, but this takes me back to what my first point was, that cases such as Countess of Rutland's, Jervis, Whitehead, and Sparks have nothing to do with criminal arrest. It has been recognized by this court that people can be seized without, it has been recognized by this court people can't be seized without taking possession of. So why would seizing in the case of persons mean a different thing other than the given meaning of seizure?
So let's introduce a new case in here. What can you tell us about what happened in the case of Whitehead versus Keyes? How applicable is that?
In the case of Whitehead v. Keyes, Your Honor, 1 second. In the case of Whitehead v. Keyes, sorry, Your Honor.
Okay, we can move on. Thank you.
They recognize the actual definition, as I previously gave to you, means possession throughout a variety of dictionaries. So this would support the fact that she was not seized until she was shot. The petitioner previously mentioned earlier that take hold of can mean just a mere touch. But if I were to just, touch a bench, that wouldn't be taking hold of. To take hold of, you actually have to hold the object or the person that you are seizing. So as you can clearly see, the petitioner has used cases that do not apply to this one today and have completely missed the mark of the definition of seizure. In conclusion, there can be no violation of the Fourth Amendment if there was no seizure. We ask this court to affirm the decision of the lower court. Thank you.
Some rebuttal?
As my opponent mentioned, she claimed that her dictionary was the most relevant dictionary by date. She herself also stated that her dictionary was 23 years prior to the writing of the Constitution. The dictionary definition that my colleague, Mrs. Davis, excellently provided was written in 1777. That is more recent, that is closer to the writing of the Constitution than 23 years. The second thing I would like to mention is that under their reasoning, if seizure doesn't occur until full control of the person, then officers could theoretically shoot someone an unreasonable amount of times before they could be constituted as seizure if the person needs to be fully restrained.
Any difference between arrest and seizure?
As my colleague also stated, arrest is a subset of seizure, but under their definition of seizure, seizure does not occur until they have full restraint of the suspect. The court needs, for future preference, for future cases, the court needs a clear bright line going forward, and the respondent's definition of seizure is not easily defined. Is 5 seconds enough for full freedom of movement? If you restrain somebody for 5 seconds, is that enough? Does it need to be 10? What are we defining? What length of time does someone need to be fully restrained? If this is not defined, there's too much gray area for what could possibly occur in that timeline. Moving forward, we utilize the mere touch concept. We have a clear definition of what does and doesn't constitute a seizure. It will help protect both our police officers
And that should apply
our
only to
suspects.
persons, not possessions?
Correct, Your Honor. Do you have a further question?
You may. Thank you.
Thank you.
Thank you. Okay, well, thank you to both sides. The case is now submitted and the court will deliberate.
Thank you, counselors.
If everyone could follow me and exit the room, we'll wait in the hallway. It'll be great.
Thank you. Thank you all for coming to the court today.
I'm sorry.
Yes. So that we can deliberate out loud.
At the end.
Thank you.
Oh, that's so bad. Okay. It looked like it was finished. I'm like, oh my gosh.
Hey, how are you doing, Leah?
Hurry up, hurry up.
I didn't recognize you in here.